Bharata. Indian polity discussion topic Directive Principles of State Policy. Throughout the discussion, what we would cover is an introduction to Directive Principles of State Policy, important features of Directive Principles, opinions of various constitutional experts, constitutional provisions, implementation of various directives in other parts of the Constitution. The provisions of Directive Principles of State Policy in the Indian Constitution are compiled in Part 4, referring from Article 36 up to 51. These directives are non-enforceable in courts and do not create any justifiable rights in favor of the individual. Despite this fact, it is the duty of the state to follow these principles both in the matters of administration as well as in the making of laws. They embody the object of the state under the Republican Constitution, namely that it is to be a welfare state and not a mere police state. Most of these directives aim at the establishment of the economic and social democracy which is pledged for in the preamble. Important features of DPSPs. Directive Principles of State Policies, as compared with fundamental rights, constitute limitations upon state action, as in fundamental rights, whereas DPSPs are in the nature of instruments of instruction to the government of the day to do certain things and to achieve certain ends by their actions. DPSPs can only be implemented through a legislation. Unlike fundamental rights, DPSPs are non-justiciable rights. Further, the conflicts between fundamental rights and DPSPs, in their understanding, what we get to know is fundamental rights are enforceable by the courts as mentioned in Article 32 and Article 226, Clause 1, and the courts are bound to declare as void any law that is inconsistent with fundamental rights. Article 37 clearly mentions that the courts cannot declare as void any law which is otherwise valid on the grounds that it contravenes any of the directives. Therefore, in 1951, the Supreme Court opined that in case of conflict between Part 3 and 4 of the Constitution, the former shall prevail. Exceptions to superiority of fundamental rights over DPSPs. Article 31C, introduced in 1971, says that any law made to implement directives under Article 39B and C shall be immune from unconstitutionality on the ground of contravention to fundamental rights under Article 14 and 19. 42nd Constitutional Amendment Act expanded this status to all DPSPs. This attempt of giving primacy to DPSP over fundamental rights was foiled in Minerva Mills case, where the apex court again confined that status to only Article 39 subclause B and subclause C. In the Minerva Mills case, the Supreme Court also reiterated the doctrine of harmonious construction. Fundamental rights and directive principles are the two wheels of the chariot as an aid to make social and economic democracy a truism. The court also held that outside these two fundamental rights, that is Article 14 and 19, the general proposition of Supreme Court in 1951 shall persist. Now, the sanctions behind the directives, the way we should understand them, there is no legal sanction behind DPSPs, as Article 37 clearly says The provisions contained in this part shall not be enforceable by any court, but the sanction behind them is political in nature. As Dr. Ambedkar observed in the Constituent Assembly, if any government ignores them, they will certainly have to answer for them before the electorate at the election time. Whether Article 355 and 365 can be applied to enforce implementation of directives by the states, it shall be the duty of the Union to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. As Part 4 is a part of the Constitution, it should be competent for the Union to issue directions to particular states to implement certain directives of Part 4. In case of refusal to comply with such directions issued by the Union, Article 365 can be applied against any such recalcitrant state. Of DPSPs: Gandhian principles, socialist principles, liberal principles. Fabian socialism without the socialism. According to Sir Ivor Jennings, the philosophy underlying directive principles is Fabian socialism without the socialism, for only the nationalization of the means of production, distribution, and exchange is missing. Fabian socialism and its purpose is to advance the idea of democratic socialism via gradualist and reformist effort in democracies rather than by revolutionary overthrow. Our Constitution did not adhere to any particular ism but sought to effect a compromise between individualism and socialism. That is why a socialistic pattern of society, not socialism, was declared to be the objective of our planning by Pandit Nehru. Further, understanding the utility of directive principles. Now, due to lack of legal sanctions behind these directives, their utility has been questioned by various constitutional experts. Sir Ivor Jennings characterized them as pious aspirations. Professor Ware goes on record saying, if the Constitution is to be taken seriously, the interpretation and fulfillment of these general objects of policy will raise these great difficulties for legislatures, and these difficulties will bring the Constitution, the courts, and the legislature into conflict and disrepute. If these declarations are, however, to be treated as words, they will bring discredit upon the Constitution also. But their incorporation in the Constitution has been justified by a consensus of opinion as well as the working of the Constitution since 1950. According to Sir B.N. Rao, these directives are moral precepts for the authorities of the state. They have an educative value. It reminds those in power that the goal of Indian polity is to introduce socialism in the economic sphere, or economic democracy as distinguished from political democracy. Granville Austin considers these directives to be aimed at furthering the goals of the social revolution, or to foster this revolution by establishing the conditions necessary for its achievement. These directives have served as an instrument of instruction on all governments, irrespective of their party creeds. These directives are not completely useless. The working of the Constitution for so many years has demonstrated their utility. Now, in case if a law allegedly contravenes Article 14 and 19, the court can uphold the validity of such law if it had been made to implement a directive. The court can use DPSPs to constitute in a law a reasonable classification for the purpose of Article 14 or reasonable restriction for the purpose of Article 19. In determining the scope and ambit of fundamental rights, the court may not entirely ignore DPSPs and should adopt the principle of harmonious construction so as to give effect to both as much as possible. The courts have been issuing directives in various cases enjoining the government to perform their positive duties to achieve the goals envisaged by the directives. Constitutional provisions in regard with DPSPs. Article 36. In this part, unless the context otherwise requires, the state has the same meaning as in Part 3. Article 37. The provisions contained in this part shall not be enforceable in any court, but the principles therein laid down are nevertheless fundamental in the governance of the country. And it shall be the duty of the state to apply these principles in making laws. Article 38, Subclause 1. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Subclause 2. The state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. Article 39. The state shall in particular direct its policy towards securing a. That the citizens, men and women equally, have the right to an adequate means of livelihood. B. That the ownership and control of the material resources of the community are so distributed as best to subserve the common good. C. That the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. D. That there is equal pay for equal work for both men and women. E. That the health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter vocations unsuited to their age and strength. F. That the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Article 39A, inserted by 42nd Amendment Act. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizens by reason of economic or other disabilities. Article 40. The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. Article 41. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. Article 42. The state shall make provision for securing just and human conditions of work and for maternity relief. Article 43. The state shall endeavour to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise, work, a living wage, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular, the state shall endeavour to promote cottage industries on an individual or cooperative basis in rural areas. Article 43A, inserted by 42nd Amendment Act. The state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishment or other organizations engaged in any industry. Article 43B, inserted by 97th Amendment Act 2011. The state shall endeavour to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Article 44. The state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Article 45, inserted, 86th Amendment Act. Provision for early childhood care and education to children below the age of 6 years. Article 46. The state shall promote with special care the educational and economic interests of the weaker sections of the people and in particular of the scheduled castes and scheduled tribes and shall protect them from social injustice and all forms of exploitation. Article 47. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular, the state shall endeavour to bring about prohibition of the consumption, except for medicinal purposes, of intoxicating drinks and of drugs which are injurious to health. Article 48. The state shall endeavour to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milk and draught cattle. Article 48A, 42nd Amendment Act. The state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Article 49. It shall be the obligation of the state to protect every monument or place or object of artistic or historic interest declared by or under law made by Parliament to be of national importance from spoliation, disfigurement, destruction, removal, disposal, or export as the case may be. Article 50. The state shall take steps to separate the judiciary from the executive in the public services of the state. Article 51. The state shall endeavour to A. Promote international peace and security. B. Maintain just and honourable relations between nations. C. Foster respect for international law and treaty obligations in the dealings of organized peoples with one another. And D. Encourage settlement of international disputes by arbitration.